Someone make it make sense.
Probably a couple.
Hello, and welcome, guys. We are here with the latest out of Karen Read. It remains to be seen when this trial will be starting. People have sort of speculated. Ostensibly, opening statements, I guess, could still happen today. They had another jury empanelment, right? We don't know yet what's going on. As of this morning, they still had 16 jurors when they need 18. So it's just sort of waiting to find out. So we've got the latest court filings here. And we also have here Karen Read's dad spoke out to local media outlets commenting on jury selections. This is just a short little video. I figured we would watch this just to see what he says, because we do know how these statements made outside of court can be brought in. And in fact, one of the new court filings deals exactly with that. However, it's not with Karen Read's dad, it's with Karen Read. But, you know, it's always interesting when somebody speaks out from her family or her to media and the implications of that. So I thought this would be interesting to watch as well. So shout out to Official, shout out to P. Fox, shout out to Nightbot, of course. Welcome. Official, were you affected at all by the earthquake? We were hoping you were okay. We were inquiring of our other California squirrel friends. They seem to all be unaffected, thankfully. So hopefully everybody is still safe. So, okay, let's jump right on in to see what Karen Read's dad had to say.
Neutral today, right? Down one, up one, so we're still holding at 16, and we're back here tomorrow. Fun and games and good times, huh?
The pace is kind of slow compared to last year. We're almost double, 5 or 10 days of jury selection. To what can we attribute that, do you think, though?
I mean, by my count, we're into 3 years in running. So, I mean, there's
Fair point.
too many people. A lot of people know what's going on, and they form their opinions. And, of course, as the parents of Karen, we wholeheartedly believe their opinions are overwhelming when they look at the evidence, the ARCA, the dishonorable discharge of Trooper Proctor.
Yeah.
It's hard to believe that we're still doing this, but we are. And a lot of people know about it. I mean, they come in and they're being honest, and they have a. Thank you. They have an opinion, and it's probably difficult to shed that opinion and listen to something over 8 weeks. And 8 weeks is a long time. I mean, for prospective jurors, the idea of being out of work, and I don't know what the compensation is here, $12, $15 a day, and that's not going to cut it. So that presents a particular handicap. So you got 6 to 8 weeks, which is a handicap. And plus, again, so many people know about the Karen Read case. It's no longer just regionally, it's nationally and internationally. And
Mr. Reed, the Supreme Court is going to weigh in at the end of the month whether it's going to take up this. Should they put this trial on hold while waiting for the Supreme Court?
Well, I mean, you're going to have to ask Judge Beverly Canoni about that. I mean, that's certainly beyond my realm. I mean, I don't understand that. My sense is, from what I've heard from the team, is that they're going to conference on the 25th. And at that point, they may announce whether or not they're going to take up the case, or they may not announce. I just don't know.
And there's been a lot of jurors who've been excused that we've seen. And do you feel that's a fair process that's taking place, that these are people who probably...
The weather official.
I think so. I think in fairness, if people have a judgment ahead of time and a bias ahead of time, favorably or unfavorable toward our daughter, my son here, I think it's in the interest of fairness and justice. I mean, that's all we want is justice, to be fair.
Mr. Reed, you mentioned that this case is national now. Yes. Today, prosecutors filed a notice that they plan to use
it's national, a long time ago,
as evidence against her, and your interviews as well. How does that make you feel?
Oh, his interviews as well. Literally, that's the filing I was just referencing that we're going to cover.
I live by the truth. I answer to a higher maker.
Higher
and,
maker.
I'll tell the entire truth, and there's nothing we are hiding in the Reed family. My daughter has spoken out of frustration. When we started off 6 months into this case, we had no idea the depth and the scope of the wall we were facing. And my daughter reached out as a way of trying to get the story out. I mean, there were never these microphones in front of us 6 months into, June 22. And now, we can't go out to dinner. We can't even go to Sunday Mass. We get
Sunday Mass.
people asking us about the case. And so,
Thank you.
All right, that's it for that one. So, by the way, I learned the other night when we were having our movie night that official can type something like 50 bazillion words a minute. It's pretty insane. So that blew my mind. I didn't even know that was like humanly possible. Okay, so there you have it. So now let me just unshare, reshare, and we're going to get into the latest filings. Woo! All right, first up, I'm going to zoom in. Kane, are you ready? Are you ready, Kane? Kane thinks I read too fast. I mean, I know I speak fast and read fast, so it's not. I'm just saying. Get ready. Get yourselves ready for this. Okay. So, unopposed motion of Gretchen Voss for exclusion from sequestration order. So, this would allow her to be present in the courtroom, right? Third-party journalist Gretchen Voss respectfully moves for an order excluding her from the provisions of the witness sequestration order in this case. Counsel for both the Commonwealth and the defendant have indicated that they do not oppose this motion. As grounds for her motion, Voss states that 1, the Commonwealth and the defendant have agreed that Voss will not be called as a witness at trial. So that's news. And 2, enforcing the sequestration order against Voss would violate her First Amendment rights. Voss further states as follows. 1, Gretchen Voss, a contributing editor for Boston Magazine, has been covering this case since its inception. She reported and wrote the story, The Killing That Tore a Town Apart, which we've read on another live stream. She's continued her reporting on the court proceedings since then. Oh, yay, Frank's welcome. And Frank's command worked excellent. Love it. Her reporting on the court proceedings since then for future coverage of the case, whether for Boston or another media outlet. Voss was not a party or witness to any criminal activity relating to this case. Rather, her connection to the case arises only from her accurate reporting of news to the public. Number 3, in response to the Commonwealth's renewed motion for records, and as ordered by this court on January 31st, Voss turned over audio recordings of 2 on-the-record interviews she conducted with defendant Reed and her counsel. It is her understanding that the Commonwealth intends to use portions of those recordings at trial. Although Voss's name originally appeared on the Commonwealth's prospective witness list, counsel for both the Commonwealth and the defendant have informed undersigned counsel that Voss will not, in fact, be called as a witness at trial. Instead, the Commonwealth and the defendant intend to stipulate as to the authenticity of the records produced by Voss, therefore rendering Voss's testimony unnecessary. Great. We love a good stipulation. Number 5, by virtue of the court's random selection process, Voss has been approved to attend and report on the trial of this case. Prohibiting her from doing so by enforcing the sequestration order against her would threaten the public's understanding of events occurring at trial and unnecessarily interfere with the free flow of information. Honestly, the thing is because they've said they're not calling her as a witness, it's really moot. So I don't really know why they're even including other things here. She's not going to be testifying. So this is what matters. Given the stipulation to which the Commonwealth and the defendant have agreed, and in view of the exceedingly narrow scope of any relevant testimony Voss might offer, the public interest in her being able to cover this proceeding far outweighs any conceivable interest in excluding her from the trial. So, I mean, there it is. There you have it. Basic stuff. Here's our next one, though. Commonwealth's notice of discovery. So the question a lot of people have been asking, right? Is anybody going to be using this Canton Police Audit report situation? I don't think Nightbot has blocked you, Kane. So it's blurry on every place I looked. This is just how it was scanned, so nothing I can do about that. But we can still make out that number 1 says in this notice of discovery, copy of Canton audit report. There it is. There it is. Bam. So the Commonwealth is going to bring that in. Copy of updated CV, Shannon Burgess. Copy of transcript Janet and William Reed interview. So that's her parents. Body in the Snow. We read that one as well. Or wait, no, that's the documentary. So no, we haven't read that because we can't. It's not something we can read. I believe that's the documentary. It's hard to remember because they all have these different names. So copy of defendant's interview, copy of transcript of defendant's interview, Body in the Snow. Copy of keeper of records for NBC Universal Dateline episode, The Night of the Nor'easter. Okay, that confirms it then. The Body in the Snow is the documentary because there it is. I think that's the recent one and I haven't seen it. But yeah, okay, copy of keeper of records. That's to get in the foundation, to bring in the transcripts. Another one called The Perfect Storm, really funny. Copy of updated expert contract and payments. Copy of CV Carl Miyasako. Copy of the Massachusetts Police Report. Number 115, copy of Ian Whiffin's PowerPoint, copy of Ian Whiffin's video, copy of Ian Whiffin's report, and copy of video and audio clips of interview statements. It doesn't specify what those are from. You can't see Nightbot's chat. That's interesting. There's some other people that have that issue. I don't know if it's just the device or what it is, which is interesting. Got it, Kane. 140 words per minute. Official was correcting. It wasn't 50 billion or whatever. I said 140. Still a lot. From what I understand. Kane is saying he wants to come back as a Giant TV. Is this referencing a future probation? Speaking of which, this should redirect you guys into Lori Vallow. We are going to be a number of things. We're going to take a look at a video from Colby Ryan from last night that is really interesting and worth watching. And then we're going to jump into part 2 of day 5, which is where it picked up with the firearms dude, toolmark dude. It's him. We have him. And then we have the detective who interviewed Lori, which is really funny because I had a feeling she was going to be next. And sure enough. So that we will be going, this will redirect you guys into that live stream where we will get all caught up on the rest of yesterday from Lori. So welcome. Backwood Beats and Outlaw Backwood Beats and Outlaw Rhythms. Say that 10 times fast. Happy to see you again. All right. Hope everything's well in Chicago. Is that how they say it? I don't know. Okay. Next up, Commonwealth's notice of intention to introduce extrajudicial statements of the defendant. Who's surprised? Raise your squirrel paw. No paws are being raised. Now comes the Commonwealth in the above caption matter. Okay. Right. Under Massachusetts law, statements of a party opponent are admissible and evidence to prove the truth of the matters admitted in them. So, party opponent, right? Party opponent is important when it comes to hearsay. Yay! I love talking about hearsay. So, in a civil case, guys, party opponent is plaintiff and the defendant, right? So both sides, party opponent, right? So if you're a plaintiff, you can use statements of the defendant. If you're a defendant, you can use statements of the plaintiff. And of course, in a criminal trial, the party opponent of whoever's bringing forth the charges, the Commonwealth in this case, the party opponent is the defendant. Now, in case you're asking yourselves, well, hang on, who's the party opponent for the defendant in a criminal trial then, right? The party opponent is the state, the Commonwealth, the government. How does that work? Well, glad you asked because I'd been thinking about this for a long time when I was getting my paralegal certificate, and I was thinking about this. And when we were when we were covering the Murdoch trial, gavel to gavel, it actually came up, and it's really interesting because everybody was really everybody. I mean, the attorneys were really thrown off guard. Like, what? So what happened was there was a point where I don't remember the exact circumstances, but I remember it was being argued by Jim Griffin, one of Alex's defense attorneys. And it was a situation where they wanted to use a statement of, I think it was probably a law enforcement officer or a detective, something like that, right? They wanted to use their statement. And, there was an objection from the state. And then Jim Griffin said, well, hang on, it's a party opponent. And everybody was like, what? And their minds were blown. But I was like, hang on, because literally, I remember when I was getting my paralegal certificate, I literally walked this through my brain. And I was like, how come nobody ever does this? Because literally they could. And it never happens. It never happens. But I was like, wait, why does this never happen? And no one had really stopped to think it through, I guess. And so, but in my mind, I'm like, how come this isn't happening all the time? Because that is a party opponent. And remember, the party opponent of the defendant is the government, which includes everybody. It includes the prosecuting office, right? It includes law enforcement. It includes detectives. It includes anybody who's under that umbrella. Sorry. And, you know, we've heard a lot about this in a lot of these recent cases where they're talking about the whole, actually it came up a lot in Coburg, came up a lot in Karen Reed, you know, it's not just the prosecuting office, right? It's everybody that's involved. So I just wanted to reiterate that is something that can happen. Party opponent still applies if you're a criminal defendant. It's just, you just rarely ever see it used, if ever. So. Oh, are you Doug? Okay, I can call you Doug. That's fine. Great. Welcome, Doug. Happy to have you here, Doug. What are you talking crap about violent players? I mean, it is definitely true that rhythm is not usually something that is as inherent for violent players because we're playing the melody oftentimes. However, it is very important. Okay. All right. So party opponent covered. Check. And there it is. Hearsay, right? There it is. Any extrajudicial statement by party may be admitted in evidence against him by opponent and will not be excluded on the ground that it constitutes hearsay. Bam, bam, bam. Thank you, ma'am. The hearsay exemption of the party opponent encompasses any extrajudicial statement made by a party opponent, not just statements that are inculpatory or against the party's interest. To admit a statement of a party opponent, there is no requirement that a foundation be laid, nor a witness that has personal knowledge of the subject. The defendant has made numerous statements to witnesses, first responders, medical providers, family members, and journalists, as well as recorded statements on John O'Keefe's cell phone. These statements range from the defendant's immediate impressions and state of mind in the minutes and hours surrounding John O'Keefe's death to crafted narrations, sometimes in the presence of counsel that recount for the defendant's version of impressions of events months and years after the murder. All of these statements are ones of the opposing party made by the defendant and are therefore admissible. The Commonwealth thereby provides this honorable court notice of its intention to introduce statements of the defendant and can provide the court copies in advance for any preliminary findings of fact that it was the defendant who made the statements. So in other words, if there's any question that it was her, we can handle that, right? But the defense, I don't think, is going to dispute it was Karen. They're not going to be, because Karen's doppelganger. The Commonwealth also moves to provide notice that it intends to introduce the defendant's own statements without a witness or in some circumstances through a non-precipient witness reader. Welcome, Miss Mandy. Well, so, you know, I know you're up on this, right? Like the opening statements were supposed to start already. But last I checked, they are still at 16 jurors. They still need 2 more. And they are still moving through the whole process of jury empanelment. I suppose there is a chance that they could seat 2 jurors and start opening statements today. We shall see. We will stay apprised and abreast of the situation. But people have been speculating it could be, and I don't know where people get this from. Some people are like, it's going to start next Wednesday. It's going to start next Thursday. I have no idea where that's coming from because literally as soon as they seat the 2 jurors, they're going to start. So anyway, you know, y'all that are on the social media sphere, if you see anything, let me know. Okay. Miss Mandy says they plan on getting those jurors today and starting tomorrow. Okay. If they get the jurors today, right? I mean, that's the thing. They have to get the 2 jurors. If they don't get the jurors, they can't start tomorrow. But it was supposed to start today. So that's why I put retrial delayed, because the opening statements were supposed to start today. And, you know, I had my thumbnail made, I had the stream set up, and then I was like, oh. So here's what I will say. I plan to cover the opening statements live. And one thing I will say too, is for any of you guys who were here last time, if anyone here is in the scroll chat now that was here last time, you can also weigh in. But what people said was this was the one channel where they felt like they could watch the trial and it was not a toxic environment. And so it's for that reason that sometimes when there's a lot of channels covering the same thing live, I won't cover it live because there's just no point. And, oftentimes people enjoy watching something, having another look, right? And like after they've digested it all. And so oftentimes, going live that evening or whatever is appropriate. However, for Karen Reed, though, I'm going to try to go live at the time, like as much as I possibly can, because of the reason that for y'all, right? Because of the fact that there's so many people who feel like they don't have anywhere else where they can, they can watch it. But in terms of the chat, right, they want to be able to have a non-toxic chat atmosphere. So whenever opening statements happen, I have every intention to be covering at least those live, if not more, but definitely the opening statements. And it just sort of depends on when those end up happening. And anything that I'm not doing live, of course, we will do in the evenings, as I kind of mentioned. So, okay, so next up, we have the last document here. This timing works out perfectly because you guys will be redirected into Lori Vallow. All right. Non-toxic. Yeah, so Kane, I don't know, were you following Karen Reed's first trial at all? Like, here's what I will say real quick, that I didn't follow. Okay, let me, that's not even accurate. I stayed as far the fuck away from Karen Reed as I possibly could until opening statements in the first trial. Here's what happened for anyone who hasn't heard the story. It's a quick one. And honestly, it was really funny. His uncle has the same story as he said on a live stream somewhat recently. And I was like, that's so funny. His quick Karen Reed origin story is the same as mine. Like the divisiveness that Karen Reed was bringing into situations prior to the first trial made me stay as far away from it as humanly possible. Okay. What happened was during opening statements, right? I was doing stuff around the house or whatever. And like, it just came on autoplay. Like it just came on, YouTube put it on, whatever. And it was during Yanetti's opening statement. And it was right at the beginning. And I heard Karen Reed was framed. And I mean, I heard the way he said it. And I listened for about all of 10 seconds. And then I was like, all right, we're covering this. So I jumped in literally that day, having literally no background knowledge at all, because I stayed as far away from it as I could. And so that's how I ended up covering it. But the divisiveness in this case is a whole thing, and the toxic environment and all that toxicity. I mean, many people, I know DSN has commented before, shout out to DSN. He said that, and I know he's not alone. He said he has lost friends over this trial. And again, I'm sure he's not the only one, but many people have offered a similar sentiment where they have lost friends over this trial, which is really sad, but that should give you some idea over. It's kind of like an election, like politics or religion. It's like that, right? With certain people. And, a lot of people had their favorite channels. And in those channels, in the chats, it was like that type of environment where people were like, I mean, it was just insanity. And so that's why, and I started covering it. And like, literally, I don't know why, it's just the Squirrel Crew's awesome, right? That's really the only thing I can say is like, it is the chat that is not divisive. And I will say we have had Mr. Lessie himself, actually, he's been here for several live streams and it has been confirmed it was him, which blows my mind. But anyway, if we're covering it live, I'm sure he won't be there because he will be in court. But anyway, so yeah, so you don't know much about it. Okay, well, hopefully you'll join us for this retrial. And I'm sure you will hear war stories from people about what it was like the first trial. And why it's such a big deal to have a place where they feel like they can watch it and have a good environment. So Mandy was one of the people who came in. I didn't think it was him, but there was another live stream where it was confirmed by EDB. And Mandy, I think, is the one who was telling me about that. So I'll let Mandy, if she's still listening, weigh in. So I didn't think it was him until Mandy mentioned something about EDB confirming it. So anywho, okay, let me read this last filing here. So Commonwealth's motion for notice of any visual aids, potential exhibits, or potential chalks that will be displayed to the jury during opening statements in front of whom this is like, what the fuck's a chalk? In Massachusetts, demonstrative aids, demonstrative exhibits, they call them chalks, right? So the Commonwealth notifies the court that it intends to introduce recorded statements of the defendant in its opening statement and will produce a copy of the recorded statements to the court in advance of opening statements for a ruling on admissibility. Interesting. Okay. So the Commonwealth is going to use recorded statements in its opening statement. Like they're going to play Karen Reed's own statements. So think about this, guys. So what was something, thinking back to the first trial, there were no demonstrative aids used during opening statements by either party that I recall. I don't think there were at all. And so this is already a change from what we had the first time. The Commonwealth, and I would expect there's probably going to be differences too from the defense, right? So the Commonwealth is going to use a demonstrative, or well, it's an auditory aid, but similar, right? So it's a recorded statement. So further, if allowed, the recordings should be marked for identification, so a complete record is made of all items shown to jurors in the courtroom during trial. Additionally, the Commonwealth moves for an order that the defense identify in advance any visual aids, potential exhibits, or potential chalks to the defendant intends to use during opening statements. And I will say also, shout out to Dr. Bob. So Dr. Bob hopefully will be able to be here for this retrial. I know he's been having some like health issues and stuff, but in case you're like, who's Dr. Bob? Dr. Bob joined us for the first trial. He is awesome. First of all, he's a local to Massachusetts. He has served as the foreperson on a jury twice, and he's a retired physics professor. So all of the great things to have when it comes to this case, right? And he's super awesome, great human being, has a really cute dog. Shout out to Bandit. We also love Mrs. Dr. Bob. So hopefully he will be there as well. Okay, so that's the latest on the documents here. So now we will be redirecting into Lori Vallow through the magic of technology. So hopefully I will see you guys all over there. We will get caught up on day 5. And thanks for watching. And again, we will stay apprised if there's any new updates regarding when this will be starting. But that's it for this one. So I'll roll the outro.